We're going to now start our last session, so we will hear from Commissioner Schiraldi, and then there will be question and answer with you and the Commissioner. I call him the Commissioner of Public. But to introduce Vinny, we have David Utter from the Southern Poverty Law Center, who I think you told me single-handedly saved the youth justice system in Louisiana. Is that correct?
Right, yeah,
Okay.
single-handedly.
Okay, David Utter.
That's funny because one of the things that I'm going to do is introduce Vinny, and it was through my work in Louisiana that I first met Vinny Schiraldi. And when I first met Vinny, he was a peer advocate, and that was his background. You see a resume here. Founder of the Center for Juvenile Criminal Justice Center, and then JPI, which has now got a long, long legacy. But I remember my first contact with Vinny when I was just starting out in Louisiana in a system that at the time, this is 1998, that was recognized as probably the most brutal juvenile justice system in the country. I remember interviewing children in the facilities there, and day in and day out, just meeting kids with broken bones and burst eye sockets and broken jaws. And it was through meeting national folks like Vinny and Mark Schindler and others that we at JJPL, at Juvenile Justice Project Louisiana, we were provided hope. And it was seeing somebody that is so passionate about kids, seeing somebody that's so passionate about justice, and also had the ability to move stuff, so articulate, so bright, so dedicated. And the fact that Vinny is now a commissioner of a major, agency, and also did the same in Washington, really for me sets the bar for what we should all be trying to have in our states. And so, without further ado, I'm going to introduce my good friend and my hero, Vinny Schiraldi.
So Dave and I went out to dinner last night with Mark Schindler and Jeff, Nishi, and my wife sat next to Dave, which is a mistake I will not be committing again anytime soon, and told him a whole bunch of stories about my juvenile delinquent path in Brooklyn, my own personal stories. And so Dave this morning saying to me, so which of those stories can I tell during your introduction? And, I want to thank Dave especially for listening to my answer, which was none of those stories. As well as I want to thank Jeremy Travis, Pinkerton, and particularly the Pinkerton Fellows here. Can we get a little Pinkerton Fellows? No. Let's see who you are. 1, 2, 3, a couple over there. This is a great program. I got to speak to you guys. Is it the same you guys, or is it a new bunch of you guys? Same you guys, okay. A while back, and I think it's great that Pinkerton's doing this. You guys should be applauded for it. And then, especially I want to thank Jeff Butts, who, on this subject of young adult justice, for me, has been the person who introduced me to the concept years and years ago, and has been my sort of thought partner for quite a while on it. So I'm going to give a different kind of presentation today than I'm used to giving. I haven't really ever talked about my ideas about a young adult justice system in public before. For most of my career, as Dave mentioned, I was before I worked for government, I was an advocate on behalf of raising the age of criminal responsibility against automatic or prosecutorial discretion waiver and for separate housing for juveniles who had committed crimes. Essentially, I've sort of given lots of speeches about having a juvenile justice system that's as distinct as possible from the adult court system. But today, as advertised, I'll be focusing my remarks on sort of the rest of the young people in the system, young folks that don't really have a specific group lobbying on their behalf. They don't have much in the way of research that identifies them as a single set of folks. There's not much academic work being done on their behalf, very little, I think, legislatively. And so I'll be focusing really on the special needs of young adults ranging in New York from ages 16 to 24, but if we were over to Hudson, New Jersey, or in all but one other state in the country, I'd be talking about people 17 or 18 to 24. What I'm saying will still hold true if New York raises the age of jurisdiction to 18, which, like many of you, I hope it at least does. So the question I'm going to ask us all to consider, and which I'm increasingly considering myself, is it reasonable to stop the discussion about raising the age of jurisdiction at 18? The more time I put into thinking about this construct, the more people I talk to, the more research I read, the more data I look at, the more I believe that, as impressive as the founders of the juvenile court were in 1899, their choice of 18 as the dividing line for adulthood was an arbitrary one, not linked to any science or data, that has become sacrosanct and has defined in terms of our debate, our research, our data collection for far too long. So while I absolutely support raising the age of jurisdiction to 18 in New York, given the emerging science about brain and adolescent development and the desperately negative outcomes that young adults have when processed through the adult system, it's increasingly clear to me that the use of 16, 17, or 18 is an inadequate borderline, and one that we as practitioners, advocates, researchers, and public officials should abandon in favor of a more sensible approach of working with these young people. So in order to get at this subject, I'm going to focus my remarks along 3 lines. First, why, whether it's because of emerging science, arrest rates, rearrest rates, cost, racial disparities, or negative life outcomes, it's important for us to create a separate system or a separate set of responses to address the unique needs of young adults caught up in the justice system. Second, what's already being done elsewhere and here to some degree to address the needs of this age group. And third, what some of the elements of such a system would look like if we were seriously to address the needs of court-involved young adults in New York. So before I jump in, I want to add I'm indebted to the work of people like Larry Steinberg, Tracy Velasquez, Jeff Putz, and the Transition to Adulthood Alliance in the United Kingdom, which is sort of a really interesting group of folks that I would encourage you guys to go online and look at. It's T2A, T number 2, letter A, Alliance, who have all helped shape my thinking on this, especially I would say Tracy, who's got a piece on this in Chronicle of Social Change, and like I said, the T2A Alliance website. They've written extensively on young adult specialized services, specialized systems for young adults, particularly in Europe. All right, so just like in the 1800s, when there was only one court system and one set of correctional facilities, and society essentially viewed juveniles as merely miniature versions of adults, Americans today think of their courts as irrevocably divided into 2 categories, juvenile and adult. And a legal act then is either that of an innocent child who cannot be held responsible, or of an adult who is fully responsible. This often results in young people who are not considered an adult for a variety of other legal, civil, or even business purposes being placed in developmentally inappropriate adult prisons or on adult probation. These age-dependent methods of negotiating that single boundary line between juvenile and criminal jurisdiction, which I called earlier magic birthday, now seems hopelessly outdated. Without today's knowledge of adolescent development, early reformers could be forgiven for setting criminal responsibility at 16, 17, or 18 on largely moral or traditional grounds. Yet such boundaries were arbitrary then, are arbitrary now, and more importantly, are contrary to the latest science. Today, increasingly sophisticated developmental and neurobiological research shows that the human brain isn't fully mature until the mid-20s. The brain system that modulates pleasure-seeking develops more quickly than the part of the brain that supports self-control. So pleasure-seeking has an edge in the race for adolescent behavior. This means that the period of adolescence is now considered longer. Tammy joked about that earlier. I got a 20 and a 22-year-old. It's no joke. Than previously thought. And as such, youth are 1, less able to regulate their own behavior in emotionally charged contexts, 2, more sensitive to external influences like peer pressure, and 3, less able to make judgments requiring future orientation. I think my kids would say, duh, to that one, right? As such, when making designations based on age, the new science of adolescence development suggests that the appropriate terrain should include youth between the ages of 16 and 24, not simply 16 versus 18. Put another way, if you support the existence of a special court or system for juveniles under age 16, 17, or 18, it's logically inconsistent not to support some kind of special system for developmentally different young adults. Unfortunately, the law too often requires hard and fast moments in ways that don't really always mesh with human behavior. So you either do enter into a contract or you don't enter into a contract with somebody. You're not a little guilty. And for culpability purposes, you either are or aren't a full adult. But real human beings mature more gradually and reach maturational milestones at different times. And as such, the demarcation of 18 as the strict end of childhood and beginning of adulthood is an artificial one, and there's no really one moment or age at which people can be said to have reached full maturity. Each year, the research literature paints a more and more complete picture of this gradual development process. Risk-taking behavior, for example, as evidenced by activities like drunk driving or using illegal drugs, is greater among 18 to 25-year-olds than among older adults. And it's also greater in complicated ways. I don't know if any of you have ever seen a video of some of the research done by the MacArthur Research Group, but it's a really interesting stuff, right? So you take a 17-year-old and put him in front of a driving video, right? And he comes to a yellow light, and he chooses to stop at about the same rate as a 30-year-old male, right? They stop pretty much a little more risk behavior, he blows a couple more yellow lights, but pretty much it's darn close. Then you put a bunch of 17-year-olds and a bunch of 30-year-olds. And those 17-year-olds blow that yellow light every time. They never even think of stopping. They go through it. Whereas the 30-year-olds, they pretty much stop at that yellow light at the same rate they stop when they were all by themselves. So it's not just maturation, but it's the effect of peer groups on them. And these weren't even peer groups chosen to be particularly negative peer groups. They were just embarrassed to chicken out at the yellow light in front of a bunch of other guys. In a study that created a composite measure of psychological maturity that includes measures of impulsivity and sensation-seeking, 18 to 21-year-olds showed significantly less maturity than 22 to 25-year-olds, and with increasing maturity beyond 26 to 30. The Pathways to Desistance study, if you folks haven't played around with it, just Google it and go on there. It's really sort of fascinating stuff. It's the longest longitudinal study of serious adolescent offenders ever done. Their words, not mine. Researchers followed over 1,300 young people ages 14 to 18 who were found guilty of serious offenses for 7 years, following 7 years, compiling a comprehensive picture of life changes in a wide array of areas. On the positive side, researchers found that changes in exposure to antisocial peers and antisocial peer pressure were related to drops in crime in 15 to 24-year-olds. On the other hand, life events that cause significant strain, like homelessness, victimization, and witnessing victimization, negatively impact on the youth's ability to age out of crime, as did psychosocial factors like impulse control and control of aggression. Importantly, the authors noted that for intervention efforts, this is potentially a story of hope. There are many possible mechanisms for flattening the crime peak in adolescence or accelerating the decline in crime in young adulthood. I would go further and argue that if you were just looking around, my God, 5 minutes? No way. I got like 20 more pages left. That's all right. I just turn up the speed. So some current proposed laws and business practices already recognize this difference, right? Marion pointed out buying cigarettes and alcohol. I kind of prefer the business model, right? How come you can't rent a car until you're 25? How come it's more costly to buy insurance under age 25? It's not that Geico and Hertz don't want your money, right? They got actuaries sitting in rooms saying that this is the way to go, right? And they don't want to bet against the house. Like juveniles, many young adults are susceptible to impulsive behavior, allowing impulsivity to govern decisions about engaging in illegal activities. And as such, sentences that are designed to deter them, that effect is blunted, and to the extent long sentences are intended to incapacitate, they're often unnecessarily long, as maturity generally brings decreasing risk of reoffending. So, with this group of young people whose charges are essentially cresting and then declining, who are neurologically less in control of their impulses and more susceptible to peers, and absent developmentally appropriate interventions are more likely to offend, it's important for us to ask ourselves, how can we do all that's in our power to nudge them in the right direction? Before I take a run at that, I want to talk about our current landscape. At age 16, as discussed throughout the rest of this conference, court-involved young people in New York essentially drop off a cliff and become enmeshed in a disjointed system or set of systems with little regard to their developmental needs, high costs, disparate impacts, and generally piss-poor outcomes. This represents a huge missed opportunity to divert them from future arrests, future incarceration, and miserable life outcomes for education, work, and mental health that attach themselves to criminal justice involvement. Young adults are overrepresented at many stages of our justice system. Nearly 3 million 18 to 24-year-olds get arrested every year. Over 200,000 are in prison, and another 100,000 are in jail. And that doesn't count the fact that about 6 to 10 times as many people flow through jails every year as the static population. When they come out, the lifetime likelihood for success takes a nosedive. 3/4 of them get rearrested within 3 years. It's the highest rearrest rate of any age group. These figures show a profound failure to ensure the transition to adulthood that our society should be assuring, and it's by no means equally meted out. As Mark talked about earlier, African American young adults are an astonishing 15 times more likely to be imprisoned than young whites, and young adults who are part of the foster care system are 10 times more likely to be arrested by age 18 as youth in the general population. In his seminal work on what was once known as disconnected youth, Mike Wald found that actually 4 out of 10 disconnected males, disconnected in that is out of work and out of school, 4 out of 10 of them were disconnected because they were currently incarcerated at the time Mike did his study. Although we've reduced our incarceration rate pretty seriously in New York City, we're hardly immune from this. 40% of adult arrests in this city and nearly half of violent arrests involve youth aged 16 to 25. By comparison, by the way, only 3% involve youth under 16. Once arrested, those young people get rearrested more frequently than any other age group. They're nearly 3 times as likely to be rearrested for a violent felony offense. Young African American and Latino males are admitted to Rikers at 11 and 5 times the rate of young whites. Unlike juveniles who are processed in the family court system, the system for young adults is virtually indistinguishable as the system from older adults. And there's, I think, a legitimate discussion to be had about whether the liberty interests of those young adults are protected more in adult court than in family court. Clearly, adult courts tend not to overparent young adults like the family court sometimes does, sometimes depriving youth of their liberty in an effort to sort of help them. And I think that needs to be discussed in any serious conversation about this, whether it's raise the age or the creation of a third system. Conversely, as indicated above, persistent criminality into older adulthood is far too common for those who enter the justice system as young adults. I, as Commissioner of Probation, can legally treat a 16-year-old exactly the same way I treat a 40-year-old. There's nothing that tells me to do anything different from a legal standpoint. I think anybody who's been into the adolescent facility at Rikers can tell you that incarceration of young people there versus the rest of the Rikers facilities is a pyrrhic victory at best. Although young adults often present with complex problems, they just as often cycle back through the system. I think the trick for all of us is to find a system, find a way that can help nudge young people in a direction of behavior change without depriving them of their liberty for trivial failures. We'll come back to that later. I'm going to cut a couple of pages out. It costs a boatload of money, and I chronicle it really well in here. Right? The 168, the one that I want to mention, it's $168,000 a year per person at Rikers Island, and we've got about 3,000 16 to 24-year-olds at Rikers Island. So the quicker of you can do the math on that one, it's in the hundreds of millions of dollars. So in total, I believe that these developmental, criminological, and economic arguments provide an ample rationale for the suggested creation of either a full-blown third system, or at the very least, a package of practices and laws that result in substantially different and more developmentally appropriate treatment for young adults. Here's what's going on in the rest of the world. Not surprisingly, the nations that make up the EU have forged much further ahead than the US when it comes to identifying young adults as a separate category of individuals with distinct needs that require a unique response. Their responses to young adult crime tend to allow for sentencing based on maturation levels rather than simply chronological age, shorter, more intensely rehabilitative focused sentences of either confinement or community supervision for young adults, confidentiality protections, or the ability to have criminal records sealed, and in some cases the ability to waive young adult down from the adult system to the juvenile system. The Council of Europe and the EU conventions and treaties are increasingly recognizing young adults as a distinct population, deserving of special treatment, housing, confidentiality, and programming. Transition to Adulthood Coalition specifically focuses just on this very issue. In their recent publication, Young Adults in Criminal Justice, International Norms and Practices, they offer us a couple of examples. In Germany, all adults age 18 to 21 have been transferred to the jurisdiction of the juvenile court since 1953. The courts there actually have the option to sentence the kid as an adult or juvenile. Ironically, they more frequently waive kids down for more serious offenses and keep the lightweight offenses in the higher level courts where they just get fined and go away. They send them down because, not surprisingly, there's more rehabilitative programming in the youthful courts, and they feel that the people who have done more serious things need more help. In Sweden, young adults can be treated like juveniles up until age 25. Mandatory minimum sentences are set aside for those under age 21. In the Netherlands, Scandinavia, and the countries of the former Yugoslavia, there are several provisions for young adults in their law that mitigate adult sentences. And in Finland, everybody under age 21 serves their time in a specific juvenile prison from which they can be released at 1/3 instead of the normal 1/2 of their sentence, and whose emphasis is on education and vocational training. Here in the US, people are doing some stuff too. Since 1978, Florida's had a youthful offender law that allows the courts to use alternative processing for 18 to 21. Dave tells me it's not all that, and some of those facilities they send those kids to are as bad as prisons, but Colorado allowed young adult offenders whose offenses occurred when they were 18 to 20 to be included in the state's YO program, which has a separate facility that focuses on positive development, education, and skill building. That actually law lapsed, but advocates there are trying to get it reinstated. Michigan's Holmes Youthful Trainee Act allows a judge to sentence a youth between 17 and 20 in a way that avoids them having a permanent criminal record if the youth successfully completes the program. And there's a bill under consideration right now to extend that to 25. And in New York, we have the Youthful Offender Law, which attaches confidentiality protections to certain 16, 17, and 18-year-olds. We have a shock incarceration program in New York that was originally designed for people 23 and under to allow them to serve 6 months instead of their full sentences. And the Mayor's Young Men's Initiative put a lot of resources into Black and Latino men between the ages of 16 and 24. All right, so if we did this here, what would it look like? Let's remember, right, when they started in 1899, right, the progressive era women of Chicago's Hull House, Jane Addams, Julia Lathrop, and Lucy Flower, literally and legally helped create adolescence in America. In fact, adolescence wasn't even a word that was coined until 1904. In creating a separate court for juveniles that provided more rehabilitation, confidentiality protections, and separate facilities from adults, they also successfully advocated for child labor laws, compulsory education, and public parks. In like fashion, I think today's advocates need to legally and practically create a period of young adulthood, but this time setting age parameters guided by science and data rather than habit or our gut. I'd like to submit a couple of things for consideration you guys can yell at me about in the Q&A period. Recognizing that young adulthood is a time characterized by impulsivity and heightened susceptibility to peer pressure, we should design our young adult system to allow for either confidentiality or the ability to seal records after a sufficient period of crime-free living to shield young adults from a lifetime of collateral consequences. Young adults could gain these rights in varying degrees through extending and expanding Youthful Offender Act protections, adding provisions that allow for sealing, even making the attainment of certificates of relief from disabilities presumptive. None of us want to be remembered by the stupidest or meanest thing we did during college. Neither should, and particularly why I'm glad Dave honored my request this morning, neither should we be permanently hobbling our young people with their youthful misbehavior. Impressionable young adults should be kept out of congregate care facilities whenever possible through a network of developmentally appropriate community-based programs. Periods of community supervision, like probation or parole, when necessary, should be short, intense, and focused on education, workforce development, youth development, and cognitive behavioral training, not simply compliance and violations. When such youth do require confinement, they should be held in separate facilities from older adults, and those facilities should likewise focus on education, workforce and youth development, and cognitive behavioral training. It's very difficult, if not completely impossible, in a New York City context to imagine such specialized facilities flourishing on Rikers Island. As states like Ohio, California, and Illinois have done for juveniles, we should create funding streams that encourage young adults to be kept locally in non-incarcerated settings, funneling the savings from reduced incarceration into programs that hold the promise of helping young people change their life trajectories to more productive lives. We should substantially improve case processing for young adults. If the city were able to modestly, just modestly reduce our lengthy case processing times so that they were just pathetic as opposed to incredibly pathetic like they are right now, we could save tens